Everyone, Dwayne Boswello's show with the Boswell Law Firm, back with our Ask an Attorney Live. It's been a few weeks since I've been able to get on here and do this, so I apologize to everybody for not being here the last few weeks. I had court, it seems, was getting set every single week at the time that I normally do these, but we are here today, and it is a beautiful, beautiful day outside. I hope people can at least see the sunlight that's shining. It is hot. It's going to be a scorcher again, but that's Houston weather for you. So today I thought I would talk about annulments. I have seen an increase in phone calls coming in and people asking about annulments and what's the difference between an annulment and a divorce and what's the better route to go. Um, Basically, at the very basic level, the difference between an annulment and a divorce is if you get an annulment, it's like the marriage never happened. There was some reason why that marriage should have never occurred in the first place. And so it's just like wiping the slate clean, and that person, once an annulment is granted, has never been married before. Divorce is a little bit different. Obviously, that shows that there was a marriage, and that marriage actually goes into the records of the state as a marriage that was ended in divorce. Um, as far as property goes, any property that's accumulated during the marriage, and it doesn't matter if it's a divorce or an annulment, it is still subject to division, even if you're getting an annulment saying that the marriage didn't happen. So you still have some rights. There are different reasons that you can get an annulment, and one of the main ones is, we have an underage marriage. So we have somebody that was underage at the or under the age of 18 at the time that they were married. Now, it's very interesting in Texas law. We kind of had a change back in September 2017. Prior to that, there was a few ways that a marriage to a minor would be legal. And after September 1st of 2017, they really, really restricted those methods that marriage could be legal. So after 2017, you must get a court order um, basically declaring the minor an adult before that marriage can occur. Prior to 2017 or September 1st, 2017, it could be with a parental consent or showing that they had been married before and that marriage had been dissolved by divorce, and the petitioning for a court order. So the court order was the third way. Um, so they've really, really restricted the way that a minor can get married now, and it has to be basically a order that declares that minor as an adult. Another way that an annulment can occur is the petitioner, the person asking the court for an annulment, uh, was under the influence of drugs or alcohol to the point where they were so impaired that they would not have been able to give effective consent for the marriage to occur. So they have to get to a point of what we call non mentis gratis, and that just means that they're, as the court says, and I'm going to read this, so drunk as to have dethroned reason, memory, and judgment, and impaired mental faculties to an extent that would render them non compos mentis for the time being. So, a big component to that, and some of the others that I'll talk about here in a minute, is that once you've discovered um, or returned to reason in the case of drugs and alcohol, that there was no voluntary cohabitation or sexual relations that occurred after the point that you regained your mental capacity after coming down from the drugs or alcohol. Another way is impotency. So a court can annul a marriage if one of the parties was permanently impotent at the time of marriage for mental or physical reasons, and the petitioner was not aware of that impotency at the time of the marriage. Um, that is a reason for default, and courts will grant that if it's able to be proved. And probably the most common way that we're looking at an annulment is a marriage that was obtained by fraud, duress, or force. And those kind of go together. Fraud is kind of its own. So there was some lie or misrepresentation that occurred, such as immigration status is a big one that I've heard. Um, or that, even some case law says that they said that they really wanted children, and yes, they were all into that, and then after the marriage you discovered that no, they never intended to have children, and they were actively preventing the contraception of any children. Or you learn of their immigration status and that they're illegal immigrants and they basically married you for their green card. um, the key to that, once again, is once you learn of the lie or the misrepresentation, and it's of such a nature that you would not have entered into the marriage if had you known, and then you don't voluntarily cohabitate or have sexual relations after that point. Duress or force, that is, you have to establish that the respondent threatened to do some act that there's not a legal right for them to do, or the threat is of such a character that it destroys the free agency. So it puts you in such a fear or a position that you don't really have the free will to make a decision to enter into the marriage. Um, and that restraint on the free, as they call it, free agency, is of such a nature that the threat is imminent, and the threat is such that the petitioner has no means of protection. So it's a little bit more difficult to get a fraud or duress. And once again, no cohabitation is an important part of that. And then finally, another way to get an annulment is that we have a mental incapacity. A court can annul a marriage based on a spouse's mental incapacity. So that one actually can be brought or continue after the death of a spouse. The grounds for annulling a marriage on a mental incapacity are a little different, and it depends on when the suit is filed, if it's before or after the death, uh, and when a spouse dies before or during the suit, and which spouse dies, the incapacitated spouse or the non-incapacitated spouse. Um, so there's some different rules that go with that. So if at the time of the marriage the petitioner did not have the mental capacity to consent to the marriage or understand the nature of the marriage due to a mental disease or defect of the mind. And since the marriage ceremony, the petitioner has not voluntarily cohabitated. Um, you'll see that's kind of a common theme of that voluntary cohabitation. Evidence of incompetency before or after the marriage ceremony may be used to establish. Um, and a court can annul a marriage if at the time of the marriage the respondent did not have the mental capacity. So you really have to look at, did this person enter into a marriage freely and willingly, and did they have all of the information that they needed in order to make a decision freely and willingly. So that's kind of the quick rundown on annulments. As always, if you have any questions, you can always reach out to me through Facebook Messenger, or you can give me a call at 832-919-6595. We have free consultations. There's no pressure, don't have to hire us if you just have a question. I always love helping and answering questions. Or you can email me at service, SERVICE, at boswelltexaslaw.com, and Texas is spelled out, and we'll get you answers as soon as we can. As always, thanks for joining me, and we'll see you next time.